wide range of the aspect of terrorism and terrorists, both under international and Indian law. So I will be primarily focusing my lecture on the international law, and the latter part of the lecture I will come to the Indian law, which is currently there. So moving on, I think the first and the foremost issue that we come up when we talk about terrorism is the lack of a comprehensive definition in the international arena as to what exactly constitutes terrorism. I am quite aware of the fact that Brazil, till date, has resisted any kind of an attempt to have a counter-terror law in its country, which has, of course, been based on its historical aspect and the kind of the society and the turmoil that it has faced. It feels that it is best not to have a counter-terror law for its country at the moment. So that is, of course, for the citizens of the country to see. India, on the other hand, if you look at terrorism, has been facing terrorism for a very long time. And terrorism to India did not come after 9/11. It came to India much before that, but I think terrorism came to the world after 9/11 because that was the hallmark of what we call as international terrorism when the September 11 attacks took place on the World Trade Center. But if you look at the situation internationally, it is after the 11th of September in 2001, when the attacks took place, the whole world gathered together to define terrorism and to tackle terrorism, because prior to that, there was never any attempt, or a very half-hearted attempt, if I may say so, to take up this issue at an international level. However, we are almost 2 decades ahead, and we still do not have one comprehensive convention on terrorism. And the only reason for that is that because of the number of states which are present in the world today, we cannot come to a conclusion as to what exactly should be a definition of terrorism. So every country, every state may have its own interpretations, but there are certain consistent features of terrorism which I think everyone agrees about. So I have listed them. If you can see it on the screen. Number one, when we talk about terrorism, there has to be violence. So violence is one of the hallmarks of terrorism. And violence of the nature which destroys property, causes death, or causes grave bodily injury. These are the kinds of destruction that the violence should be leading to. Now, the most important aspect of terrorism, of any definition of terrorism, I personally feel should be the mens rea, or the intention, the mental intent to cause terror. Because without the intention to cause terror, you cannot have terrorism. It is any other act of murder or a common crime that you may face. But what distinguishes terrorism from common crimes is the intention of the perpetrator to cause terror amongst the civilian population, so to speak. Now, of course, intention is to cause terror with the further intention of the motive being to manipulate the government politically or in any other manner, maybe to gain some kind of perceived political, military, religious, or other philosophical benefit. So this, if you look at it, is more or less what we would signify is terrorism when we talk about it in general terms, because we do not have a proper definition. Now, I would like to move on to the counter-terror framework, which is present under international law. And I have sort of divided it into 4 categories. I know the time is short, but I will attempt to touch upon all these 4 categories in my lecture today. The first one, of course, is the international human rights law, which deals with the aspect and concept of terrorism. Then you have the international humanitarian law, and then we have the international refugee law, and of course, the international criminal law. So let me take this up one by one. Okay. Now, while we talk of human rights and the human rights principles in the context of terrorism, first of all, let me share with you, and this is a fact which everybody, I think, is aware of, that terrorism infringes upon guaranteed human rights. There is no doubt, there is no contest about this fact that terrorism is a violation of human rights in itself. However, the problem arises when we talk about counterterrorism, because counterterrorism today is being used in a way that its effect on human rights coincide with those of terrorism itself. So, for example, the issues of torture, of wrongful prosecution, repression, etc., is very central to the discussion of counterterrorism human rights link. And states or countries usually feel that as far as counterterrorism is concerned, their actions cannot amount to terrorism itself. So, but you have situations where governments are actually, in the name of counterterrorism, infringing on the human rights of people, especially on the ground that we need to do this because we need to counter terrorism. But we have so many, so for example, if I tell you that after the 9/11 attacks, most countries enacted counter-terror laws to tackle the threat of terrorism in their own countries and adopted various policies to counter terrorism. And one of the things which you might have noticed was that those people who were traveling were at the airports, they were subjected to security, very intense security checks. This was very soon after the September 11 attacks. Now, of course, the security checks are, of course, fine, but that some of the security checks, especially in the United States, entailed the passing of some radioactive light through the bodies of the people who were traveling. Now, this is an intrusive security check, which has human rights implications. Examples like this are clear violation of human rights. Again, to give you an example, if you talk about the United States military authorities who inflicted torture and degrading treatment on the Iraqi detainees in the aftermath of the 9/11 attacks. So, along with the arbitrary detention of some non-US citizens, some people were secretly deported to different places. They were tried as people who were accused of terrorism without any particular charge being put on them and without being given any access to a lawyer or a counsel because they were classified as enemy combatants. So, of course, terrorist acts constitute serious violations of human rights, but a very important fact is also the matter of the counter-terror laws also resulting in the violation of human rights of the people itself. So if you look at the range of human rights instruments available to us, I think you all must be aware of this because we have all been studying this through the course of our legal studies. One is, of course, the UDHR, that is the Universal Declaration of Human Rights of 1948. And then we have international human rights conventions, the Convention on the Elimination of All Forms of Racial Discrimination. Then we have the Covenant on Civil and Political Rights and the Economic, Social, and Cultural Rights. And then the Convention Against Torture and other cruel, inhuman, or degrading treatment, etc. And of course, the Convention on the Rights of the Child. So what I am trying to say here and put across is that along with the fact that terrorism violates human rights principles, our counter-terror laws must also be wary of the fact that they can also result in violation of human rights. So when we talk of counterterrorism, it is not only with the perspective of a terrorist that the governments must enact those laws, it is also keeping in mind that the governments cannot take it easy when we talk about the human rights, the fundamental rights, like the right to life, the prohibition against torture, the right to liberty, the right to movement, the right to equality, etc., while enacting their counter-terror laws. So a very important point to be kept in mind with respect to the international human rights law. Now, coming to the international humanitarian law, humanitarian law, I will again here divide it into two parts. Let's firstly talking about terrorism during armed conflict situations, and then I will move on to terrorism which is carried out or perpetrated during peacetime. Now, the word terrorist is not defined under international humanitarian law, IHL. Yes, the humanitarian law prohibits terrorist activities. For example, it does not allow, and it's in its instruments you will find that there is this principle that it talks about, where the deliberate perpetration of acts of violence against civilians or civilian objects would constitute war crimes under international humanitarian law, and they should be, which should be prosecuted accordingly. For example, if you take the example of taking of hostages. Now, we have an international convention against the taking of hostages, but it is similarly prohibited under the Geneva Convention in situations of non-international armed conflict. And the Fourth Geneva Convention, which governs situations where individuals who during an international armed conflict or occupation find themselves in the hands of a party to the conflict or occupying power of which they are not nationals. So clearly IHL prohibits the such activities and prohibits indiscriminate and disproportionate attacks which have similar characteristics to terrorist attacks, whether they're perpetrated during peacetime or during situations of armed conflict. I hope I'm audible to everyone, and I hope the screen is visible. So if you could just nod, yeah, okay, great. Further, if you look at Article 51(2) of the Additional Protocol 1 and Article 13(2) of the Additional Protocol 3, acts or threats of violence of which the primary purpose is to spread terror amongst the civil population are prohibited. So those acts or those threats of violence of which the purpose is to spread terror amongst the civilian population is prohibited under the both these additional protocols 1 and 2. And also, if you look at the International Tribunal, Court of Tribunal for the state of former Yugoslavia, in the Gallic case, they have again reiterated this particular primary purpose, which I have mentioned in the additional protocols. The criminal mental intent requirement falls within the general prohibition of attacks against civilians. Another issue when we talk about humanitarian law is the very big question which has bothered all of us throughout our studies of international law, because generally we say that international humanitarian law does not cover acts of terrorism, but my effort here is to tell you that even given the existing provisions of law, we can consider terrorism to be covered under the international humanitarian law. So one of the problems which arises usually is how to classify terrorists, because they are non-state actors. And international humanitarian law basically is supposed to apply only to states. Now, therefore, the suggestion is to classify these terrorists as either combatants or civilians. These are the two categories under international humanitarian law which we deal with. So terrorists actually do not fit into the category of combatants because they do not have a proper military code. They do not have a military uniform. They have not attacked like a military would attack. They are not dressed to portray themselves as combatants, otherwise are interpreted under international humanitarian law. Nor are they civilians. They are not the common innocent people of the state. So normally, the terrorists have been classified as unlawful combatants. Unlawful combatants does not lend itself, this word does not lend itself to any clear interpretation. And that is where the problem really arises for us. Because, sorry, I just scroll down the screen. Yeah.
Shruti, you are muted.
I'm so sorry. I think there was some confusion there. Yeah. Now, when we say that the terrorist is to be covered under international humanitarian law, what must be determined is the extent of their connection to the party to the conflict, which means the two parties to the conflict. Is the terrorist group a part of one of the parties to the state, or is it also helping that particular party, or is it the sole party to the conflict in terms of the one party that we are talking about? So when we say that there is a terrorist group that has attacked a particular state, so or it is also supporting a particular state which has attacked another state. So what is the extent of the connection? Is it connected? So that is the very important point that we have to talk about here. That is there a valid connection between the terrorist group to the party to the conflict? If the answer is yes, then international humanitarian law will apply. And the example is that when the 9/11 attack happened, it was presumed that it was an attack by Taliban, which would be covered under international humanitarian law, which would give rise to the right to self-defense of the United States. Now, Al-Qaeda, which was the terrorist group which had actually gone ahead with that attack, was directly supporting the activities of the Taliban government in Afghanistan in 2001. So here it was held that it is a terrorist group, which even though it is a non-state actor, would be classified under international humanitarian law for the purpose, and this would be considered an armed conflict. If we take the other position that it is a random terrorist attack, it is not something which could be covered in terms of an armed conflict, then that terrorist attack would come under terrorism during peacetime. So that is peacetime terrorism, which is different from terrorism during armed conflict. Another aspect which comes into focus is that of foreign terrorist fighters. Foreign fighters who, as you're aware, especially with the terrorist group, which we have named and the United Nations has named as a terrorist group, is the ISIS or ISIL, which operating in Syria and Iraq. So it has been found very commonly, especially in Europe and the countries surrounding them, and many from America as well, that a lot of nationals of those countries have left their nations and gone and joined ISIS or ISIL and have shown the support to them. Now, as ISIS has gone down in terms of the attacks that it is perpetrating and the control that it had originally exercised, those people, these foreign fighters, find that they have nowhere to go. So they then return to their home countries where they continue with their acts of violence and terrorism in their home countries. So they are coming back trained under the ISIS as terrorists and then continue to cause terrorism in their home countries. So how have those people been dealt with by the nations or by their home countries? So in those situations, the countries have dealt with them through various tactics of detentions, punishing and prosecuting them under their own domestic terror laws, maybe in certain instances, taking away the statehood of those persons as well, and carrying out and dealing with them as they should be dealt with under the domestic criminal law of their countries. Moving on to terrorism during peacetime, or what I call is peacetime terrorism, which is classified as an international organized crime. So like drug trafficking, like money laundering, like prostitution, peacetime terrorism is also categorized as an international organized crime. Now, when we say that it is peacetime terrorism, then automatically the Geneva Conventions and their additional protocols, which only apply to situations of armed conflict, will not apply to peacetime terrorism, to situations which may be caused because of internal disturbances or isolated random acts of violence, which I'm sure you people also must be familiar with in Brazil. Like we are in India, because these are internal disturbances and may not classify to be even international in nature. Now, the point here is that how do you deal with such peacetime terrorism? So if terrorism is being perpetrated or is occurring outside a war situation, it should be regulated under the international criminal law through the international conventions which talk about different aspects of terrorism and the Security Council resolution. Now, it is said that sometimes some aspects of international humanitarian law which apply to armed conflicts also apply to peacetime. And there is a suggestion which has been made that we should treat the categories of terrorism as peacetime equivalent of war crimes. However, the problem with this is that if we treat them as war crimes, then terrorists get the benefit of being declared as prisoners of war. So they will get that beneficial treatment under international humanitarian law, which goes in their favor and does not really help our cause. Moving on to the third aspect, which is the international refugee law. Under the 1951 Refugee Convention, refugee is defined as a person who requires the protection of the people from political or other forms of persecution. So any person who is being persecuted in their home country, who runs off and comes to another country and seeks asylum or refuge in that country is called a refugee. And every person under international law has a right to seek asylum from another country. Now, yes, a refugee cannot be asked to leave without cause, but in certain circumstances, the countries, the states can expel the refugees on the grounds that they are a threat to their national security or they are a threat to public order. So this is a legitimate ground on which a state can expel a person who is a refugee. Just to clarify that refugees in the first instance are not terrorists, They are in fact escaping terrorism in their own countries, and they have come to your country. And international conventions do not provide any kind of safe haven to terrorists. So terrorists will not be provided, or are not actually to be provided, any kind of a safety. So let's say a terrorist commits a terrorist attack in India and runs off to maybe Pakistan. Pakistan is not supposed to give refuge to such a person. He's supposed to hand over that person to be dealt with according to the law of maybe international criminal law, or maybe to the in terms of the domestic law of India, which talks about terrorists. A very pertinent point here is the Security Council Resolution 1373, which was enacted in 2001 after the 9/11 attacks. Now, this particular Security Council reservation is very clear in how refugees have to be dealt with, specifically in terms of preventing the movement of terrorists. So the states, all the member states have been ordered that whenever we talk about a terrorist, you have to ensure that you have put in place effective border controls. You do not allow terrorists to cross your borders just like that. You must secure the integrity of the identity papers. So what are your identity documents, your passport, or your whatever identification card that you possess of your country, that must be with you in your possession when you travel from one country to the other. It must be a legitimate travel. And the states were also ordered that no person should be granted asylum. A person who has planned or facilitated or participated in a terrorist act is not to be granted asylum in any country, because he is a criminal who is a terrorist and therefore must be prosecuted accordingly. This has been done to ensure that refugees do not exploit the status which is given to them under the international refugee law. It should not be abused by the perpetrators of terrorist attacks. So this is a very pointed notification or an order issued by the Security Council, Resolution 1373, which was the first Security Council resolution to set up the Counterterrorism Committee at the United Nations level. And it has been doing great work thereafter in tackling terrorism internationally. Lastly, is the principle of non-refoulement. I think everyone is familiar with this particular principle, because this principle has been, again, the hallmark of the refugee law when we talk of the international refugee law. And refoulement, which basically the principle of non-refoulement prohibits the expulsion or the return of refugee to their home countries in certain circumstances. So what the principle states is that no state shall expel or return a refugee in any manner whatsoever to the frontiers of territories where his life or freedom could be threatened on account of his race, nationality, membership, etc. I hope this particular aspect is clear to you. Great. Now, coming on to the international criminal law. Of course, we have the International Criminal Court set up under the Rome Statute. But till date, we do not have a proper, we do not have the International Criminal Court dealing with terrorism as a specific crime. So you may decide to include it under crimes against humanity or any of the other grounds which are there to invoke the jurisdiction of the International Criminal Court, but specifically the ICC does not deal with terrorism. And therefore, when we talk about terrorism under international criminal law, we talk about the various conventions that the United Nations has promulgated from time to time. There are, in fact, 19 United Nations conventions against terrorism. So terrorism has still not been defined particularly, and there is no one single convention which is a comprehensive convention on terrorism, although we are in the process of drafting that one. The process started after the 9/11 attacks, but since we have not been able to reach a consensus on the definition of terrorism, we have not been able to, sit down and say that this is the final draft of the terrorism convention and this is what we should be using. So there are different aspects of terrorism which have been prohibited under the conventions. Offenses which are related to civil aviation, for example, the taking of hostages, hijacking, kidnapping of diplomats, the use of nuclear materials, or the safety of maritime navigations, etc. The financing of terrorism, that is a very, very, very important aspect, because terrorists are non-state actors and they need financial funds to go ahead and carry out their acts of terrorism. So any kind of funds coming to the terrorists helps their cause. And this is one thing which has been specifically targeted by the United Nations Security Council, the Counterterrorism Committee, and under the international law. Financing of terrorism in any manner is completely prohibited. Then we have various United Nations General Assembly and Security Council resolutions, which again prohibit and criminalize acts of terrorism. And they ask the countries to enact counter-terror laws and incorporate different aspects of counterterrorism in their domestic law. Moving on to the aspect of terrorists have been proscribed by the United Nations, which means they have been banned. There is a list of terrorist groups and individuals who have been banned. Now, what does the international law or the United Nations do to deal with such people? They can only implement sanctions against these individuals and entities supporting terrorism. So what are the sanctions which are allowed to be implemented? The United Nations member states are supposed to impose some kind of assets freeze, travel bans, and arms embargoes. So these are the three things: asset freeze, travel ban, and arms embargo on persons who have been designated by the United Nations Security Council as terrorists. Further, the countries are ordered to implement domestic measures to criminalize any kind of support of terrorism. The Security Council Resolution 1267 of 1999, which was the Al-Qaeda sanctions regime, was the first regime which started imposing sanctions against terrorists. Then in 2011, the 1988 United Nations Security Council resolution added another list to it, which was the Taliban sanctions regime. And third came in 2015, that was the 2253 United Nations Security Council resolution, which is dealing with the ISIL or Daesh and Al-Qaeda sanctions list. So these are the three lists that we have which deal with the list of terrorists associated with these three major groups. Although the 2001 1373 United Nations Security Council resolution allows the member states to include and suggest terrorists who may not be associated with either the Taliban or the Al-Qaeda or the ISIS. So it could be anybody, maybe a terrorist from the point of view of their own country, which can be included as of banned groups. The only criticism of this procedure is that this happens, the ban happens without due process of law. The terrorists or the groups are not given a chance to explain themselves, and there is lack in terms of what is when they impose a ban on terrorists and both. So this was about the international law, and I have about, I think, 15 more minutes. Hannah, how much time do we have left?
Yes, Shruti. It can, if you
Okay,
want 15
so I'll
minutes,
quickly
okay.
take you through the, yeah. So no, I'll try and take up 5 minutes and wind up, and then we will move on to the questions. So in my last part, I am going to briefly talk to you about the counter-terror law in India, how it is going and how we have been able to deal with it. India, as you all know, was under the colonial rule, the British rule, for a very, very long time. And it was only in 1947 that we got our freedom. So we have had a lot of history with terrorism before independence as well as after independence. Um, it is internal disturbances also that we have had to deal with, and also external attacks from neighboring countries, because India was partitioned into Pakistan and India, which is a partition which happened with consensus, but it left a lot of bloodshed in its wake. And this particular aspect of the partition continues to show us its horrific side even till date, because Pakistan still feels that Kashmir is a part of its territory, and India feels that Kashmir is an integral part of India and always has been. So this has given rise to a unique kind of terrorism taking place between the two countries. And to tackle that and various other aspects of internal terrorism, we have had through the years a spate of laws dealing with terrorism. The first one was popularly called as TADA, that is the Terrorist and Disruptive Activities Prevention Act, which was enacted in 1985, and it continued for 10 years till 1995. This was actually enacted by the Congress government in India when the Prime Minister was assassinated. Indira Gandhi, our Prime Minister at that time, was assassinated by certain people. And that was when we felt that we needed some law to counter this particular aspect. Thereafter, because TADA was criticized because it had been really misused at the hands of the authorities to target innocent people, which I feel is also probably a concern for Brazilians, because in your country, you have not yet enacted a particular law, maybe on the apprehension that it could lead to misuse. And that is a very legitimate concern. So it was repealed because of the criticism it received. And thereafter, in 2002, for 2 years only, we enacted the Prevention of Terrorism Act. The short term of this act is again attributed to the misuse that this act was, how it was misused by the authorities. Again, so many people were targeted, and when the cases came to court, so many people were let off as being accused without any reason and without any legitimate grounds. Thereafter, in 2004, so 2002, why we enacted POTA was because of the attack on the Indian Parliament. That led to the enactment of this law. Thereafter, in 2004, after the repeal of POTA, we enacted, or we actually amended an old law called the Unlawful Activities Prevention Act of 1967. Now, that law originally did not deal with terrorism. It only dealt with unlawful activities, but it was amended to include terrorist activities in 2004. And thereafter, in 2008, the worst attacks on India, which were the 26/11 Mumbai attacks, happened. And that led to a very strong amendment in this particular law, which widened the definition of terrorism to include so many more acts, and different aspects, new aspects of terrorism were included in this particular amendment. The most recent amendment has happened last year in 2019, where the government has also, in addition to making a list of banned terrorist organizations, it is also now categorizing individuals as terrorists. And because of that, it has received a lot of criticism because of the question that when the law takes its course, when a person is tried through the due process of law in the court of law, he or she will be designated a terrorist and will be punished for the crime of terrorism. So where is the need to actually designate a person as a terrorist before going to the court of law, before following the due process of law? And lastly, we have the National Investigation Agency Act, which is basically an act to investigate such crimes, which authorizes certain authorities, the NIA, which has been set up at a national level to particularly investigate and prosecute terrorist acts in India. So I hope I have been able to share a brief overview of both the international and Indian law. It's a huge and a very wide field, and therefore I have tried to just give a brief overview because it was not possible in the 45 minutes to go into detail about the different aspects. So that is all I have to say, share with you today. I hope if you have any questions, you will share it with Gustavo, who will share it with me. And I hope I will be answering them to your satisfaction. Thank you, Gustavo and Hannah, for having me for this lecture. It's been a pleasure, and hope to see you soon again in our part of the country. And I tried to learn this word, obrigado. I don't know if I pronounced it correctly, but that is how I will say thank you.
Thank you, Shruti. It was an awesome lecture. So many aspects of terrorism and so much knowledge. And we receive as some questions. I received one concerning the concepts of lone wolf terrorism. It was a student of the studies group of PUC, and she would like to know this element of intention to cause terror, of how we can prove this intention to cause terror.
Okay. So when we speak of causing terrorism or causing terror, because that is how this word has originated, from the word terror and from the French word terrorisme. And this is how you distinguish between a common criminal who may be a murderer and a terrorist. So when we look at a murder, for example, the intention of the murderer is simply to kill a particular person, and he carries out that act, and that is the end of it. However, a terrorist will choose to kill people, or maybe one or maybe more, but that is not his intention. How do you decipher his intention? Is from the impact his act has on the population, surrounding area. So, in the manner the act is carried out of killing people, is it to create terror? Is it to generate a feeling of terror and extreme fear amongst the people? Let me give you the example of, maybe a kidnapper kidnapping any common man or a child for ransom. Now he takes a child for ransom, and that is his motive and that is his purpose. That is the end of it. But if a terrorist is kidnapping a person, for example, there was a time when the ISIS was kidnapping or taking hostage international journalists from different countries. Now, what was the purpose? After that, after taking the person as a hostage, they used to release a video of, cutting his neck of this hostage in a manner which would generate fear amongst the people who are watching it. So their objective was not really to capture a person or kidnap or take a person as a hostage. Their purpose was to generate fear amongst the people. So they made a video where the person was made to wear a hood, but they would show another hooded man, chopping his neck off in a manner which was horrific and which would generate fear. So why were they doing this? It was to generate fear. The reason why they again were generating fear was they wanted that the country of which this person was being killed, of which he was a citizen, that country's government should to carry out a particular act, or maybe give them money in a manner, because there's a lot of public pressure now on the government of that country to ensure that the country pays up so that these kind of things do not happen again. So it is the manner in which the act is executed which will display the intention of the person, and which will distinguish him from a criminal and from that of the difference between a criminal and a terrorist in that sense. I hope that is sort of explains the question.
Yeah, I think Hannah has received another question.
Yes, I am reading here.
Yeah,
I am receiving the question.
But we kindly ask the answer to be brief, since we have 3 minutes left. But,
okay, sure.
Yeah, feel free. It's okay.
I received a question about India in the Security Council of the UN, that India had this priority of counterterrorism during its campaign on the Security Council, and the person would like to know how India approached this theme about counterterrorism in the Security Council.
So India is basically now set to take over the leadership of this particular committee on counterterrorism now in the next year, and it will have to play a very prominent role, and it is already playing a prominent role in terms of designating terrorist groups as terrorists and also individuals as terrorists, and therefore also prohibiting and ensuring that sanctions are imposed on such individuals or terrorist groups, sanctions with respect to their assets freeze, travel bans, and arms embargo. So this is the basic purpose of the Counterterrorism Committee and the role of the members of those committee who are there, to ensure that there is no financing of terrorism which takes place, and to impose sanctions on people who are perpetrating terrorism. So that will be all from my side.
I think Gustavo, did you receive any question more?
Oh, no, we have not received any other questions. So I think, yes, that's it.
No, so I think that is Shruti. Thank you so much. It was an awesome lecture, and we hope to see you maybe on Rio de Janeiro one day after this pandemic, and to make more lectures with you and continue to contribute, both of us.
Thank you for having me, Hannah. In case anybody else has more questions, please feel free to email them to me and I will get back. I know about the time constraint, but it's been a pleasure to have all these students. And I saw somebody with the name ISIS, and I was wondering whether it's the ISIS in Syria and Iraq or it's somebody else.
I saw that name as well, and I thought it was kind of ironic during this lecture. But Isis is a common name in Brazil, and yeah, it's
Oh,
just an
okay.
unfortunate lecture. Yeah, for to appear with that name.
I'm sorry.
It's definitely ironic, but what
It
can you
is.
do, right?
Well, it's always great to have some lighter moments. This
Yes.
was one. So, thank you, everyone. Thank you for having me.
Oh, thank you. If I have another question, I will send to you by email. Thank you so much, Shruti.
Sure. Thank you. Thank you both and all the students. Gustavo, Hannah, thank you.
Thank you, Shruti. If I may ask you one last thing, actually, is it possible for you to send these slides to us?
I've already sent it to Hannah. I
Oh,
think
okay.
she can share it with you.
Okay,
Yeah,
thank you. I was not aware, but okay, thanks.
Thank you.
Thank you. Bye.
Bye.